Welcome to Court Helicopter Explainer. Today we are dealing with the question of gifts. Have you ever given your girlfriend a gift and you want it back when you have differed? Have you given your husband or your boyfriend something, a gift, then you want it back? Have you bought a car, an Uber, for your loving girlfriend or boyfriend and you want it back? Did you take a loan to buy a property for somebody and you want that property back? What is the emotions behind it? You work so hard to get this property, but all of a sudden somebody runs away from you. We dealt with the question of educating girlfriends and they run away. We talked about where you have gotten money and somebody gets a job. Today we are looking at a very interesting matter. This is a matter where a foreign woman, a mzungu woman, came to Mombasa. She loved a waiter. They started a love affair. She invested over 40,000 euros into this man. Then she wanted her money back. This is the famous case in the High Court of Kenya at Mombasa, civil case number 284 of 2007. Magragron Strata, the plaintiff, versus Bayer Abram Wanje. The facts pleaded as giving side to the suit are that sometimes in the year 2006, the plaintiff visited Kenya as a tourist and stayed at White Sands Hotel, where the defendant worked as a waiter. The parties became friends and became intimate, as a result of which intimacy, the plaintiff developed trust in the defendant, on which account the plaintiff, that's the woman, the mzungu woman, wired into an account number operated at a certain bank in the name of the defendant, the sum of Kenya shillings 40,000 euros. It is alleged that the plaintiff, that the money was so transferred to the defendant's account not for his use, but for the sole purpose of the plaintiff, and that it was used to purchase the motor vehicle and the parcel of land, and that it was at all time held in trust to the benefit of the plaintiff. So this lady, the mzungu lady, is saying, I deposited 40,000 euros into his account. One, to buy land, to use, but also to hold that land and the car in trust for me. That is where the legal question is. When you are given a gift, are you holding that gift in trust for somebody? We dealt with the law of trustee. If you are registered as a trustee, then that is not your property. She went further and supported her evidence, in which she said that he met the defendant in September 2007, that he came back to Kenya to live, and the defendant had held him into believing that she, being a tourist, could not buy anything in Kenya in her name, nor open an account in her name, and that as a consequence of such representation, and the defendant being her friend, she banked or wired into the defendant's account Kenya shillings 40,000 euros on 8th of June. So as they were talking, the man told him, in Kenya, a foreigner cannot own land. 2, a foreigner cannot open an account in a bank. So you have no option other than to send money to me in my account and buy land, pay, and the title deed will come in my land. How many of you have done that? How many foreigners have been told this? This explainer is purely for the foreigners who are coming to Kenya. The plaintiff equally produced a copy of a certificate of title over CR number 24167/1 as Exhibit P3 and said that the property was bought at Kenya shillings 700,000 and a receipt of Kenya shillings 630,000 was issued by an advocate's law firm in the name of both the plaintiff and the defendant, being purchase price of the sued parcel of land. She further stated that the advocate informed her that he could not buy the parcel of land in her own name. The advocate told this lady so. She went on to state that she bought the motor vehicle registration number this at Kenya shillings 1.3 million for own use, and that it was also registered in the name of the defendant, and that the purchase price was withdrawn from the account of the defendant into which she had wired the money. Another motor vehicle registration number so and so was bought at Kenya shilling 700 using money from her own account and not using the funds deposited at the defendant's account. A sum of about 2 million shillings remained in the account after the purchase of the parcel of land and the first motor vehicle, and that she used about Kenya shillings 1 million on her expenses, and that another 1 million shillings was withdrawn by the defendant and banked at KCB in an account held in the name of the defendant's son. He prayed that the property be transferred into her name so that she moves on with her own life. So the man, some of the money, he transferred the money into his son's account. The mzungu has come saying, I want my property back. Love has broken. We do not. Remember, we did the episodes of the Fala. You mean Wazungus can also be Fala? My crew, Bramwell, tells me a Mzungu cannot be conned. Let us see how it unfolds. On cross-examination, she confirmed the dates when she came to Kenya for the first time, but later corrected to say it was in September 2006. On further cross-examination, she confirmed that she earned the money through hard work, because she was asked by the advocate, where did you get these 40,000 shillings? $40,000. My God. She confirmed that she had earned the money through hard work for a period of 52 years, and that she could not afford to give a gift of 40,000 euros. This woman worked for 52 years. Saving of 52 years. Are you 52 years old? No. This woman toiled in our country for 52 years. She saved 40,000 euros. She found a lot. She came on a tour as a tourist. She found a Kenyan waiter. She fell in love. She invested 40,000 euros. 52 years saving. What did the man say? On his part, the defendant filed a statement of defense in which it is pleaded that the sum of Kenya shillings 40,000 euros was willingly and without coercion transferred into his account as a gift in consideration of good company he offered to the plaintiff, and that he was not answerable to the plaintiff in the manner he was to use the money. The man said, yes, I received 40,000 euros. It was compensation for my good company. You were lonely. You came. You're an old Mzungu. I'm a young man. I gave you company. I gave you validation. I made you happy. I made you laugh. That was my compensation. And once you have given me the gift, I am not bound to be directed how to use this money. On the vehicles, He pleaded that the same were bought by own money, for which reason the woman had no right to lay a claim over the same. However, for the parcel of land, he conceded and acknowledged the plaintiff's right to 50% of the interest therein. The defendant concluded his defense by stating that this suit is a design to recall a gift given by the plaintiff to the defendant, which the defendant contends is not enforceable as a right. So the man is saying, this is a gift. You cannot tell me to return a gift. You gave me, that's mine. In support of his pleadings, the defendant gave sworn evidence to the effect that the plaintiff was his girlfriend, having met her in 2006 and parted ways in 2008 after 2 years. He denied misleading the plaintiff nor cheated her over her money. He testified that the money was banked into his account as a gift and without any directions on how it was to be utilized on an account of the fact that the plaintiff was his girlfriend. On the parcel of the land, the defendant admitted that the property was bought and registered in joint names for the purpose of being developed as they intended to live as husband and wife. On the motor vehicles, the man was affirmative that the vehicles were bought by himself from own money and that the plaintiff has no maintainable claim over the same. As at the time the parties gave evidence, it was common ground that the plaintiff was in possession of one vehicle while the defendant was in possession of another. According to the defendant, the plaintiff came into possession of that motor vehicle on account of the fact that on the day the parties parted ways, the defendant had gone to work, and when he came back, the plaintiff had locked the home gate with a car inside. He sought that the cars be given to him and the parcel of land shared equally. On cross-examination, he admitted having gone with the plaintiff to buy the car because she was a girlfriend. That at White Sands, he earned Kenya shillings 30,000, which was banked in the same account in which the plaintiff also wired the money. He was, however, not sure how much was in the account before the deposit of the plaintiff. On re-examination, the defendant said there was no written memorandum by the plaintiff on how the money was to be used, and in addition to the salary, he earned service fees which depended on the guest served and would push his salary by a sum of Kenyan shillings 20,000 and 40,000 shillings per month. So the judge, what did the learned judge say? To this court, a determination of the purpose of the money determines the entire suit. What is not disputed is that the parties met in 2006 while the plaintiff was visiting Kenya with her husband. She went back to Netherlands but came back in January and February 2007. It is confirmed by both that they developed intimacy, and in the words of the defendant, they proposed and hoped to buy a house and live as man and wife. However, that was not to be, because it would appear sometimes on November 5th, 2008, there was a disagreement and a fight, as evidenced by the P3 form filed and the plaintiff's list of documents. Soon thereafter, to be precise, on the third day, being 8th of November, this suit was filed. Could there be a correlation between this suit and this agreement? How does that impact on the parties' earlier intentions? The judge says, more importantly, the plaintiff has pleaded particulars deceit against the defendant, which are akin to allegations of fraud or just obtaining money by false pretense. That, to this court, is a quasi-criminal and would attract a burden of proof that is above the proof of a balance of probability. To this court, the plaintiff did not meet her honors of proving the particulars of deceit. In fact, in cross-examination, the witness said, the lady, I did put in the money willingly. I was not forced. And I repeat, the woman told the court, I did put in the money willingly. I was not forced. The judge goes and says, this kind of evidence to this court resonates well with the defendant's account that the money was sent for a gift, as a gift, and for the purpose of buying the parcel of land for a home to be used by both as a man and wife. I'm not persuaded that the plaintiff was misled on how to handle her money and investments. To me, the judge is saying, to me, she fell in love with a proper African man, Kenyan man, and was dealing with the defendant as a lover, and for that matter, a prospective husband, till the parties differed as aforesaid. In the absence of proof of deceit, the basis upon which the plaintiff's suit is grounded fails, and it follows, therefore, that no burden has been shifted from the defendant to prove that the money was a gift and nothing else. Under Section 107, 108, and 109 of the Evidence Act, the burden was always upon the plaintiff, the woman, to prove her case because it was her seeking remedies, and thus the person to lose if no evidence at all was led. This determination answered the first issue in the affirmative, with the consequence that the answers to the issues number 1A and B are themselves determined on the foregoing. Without proof that the money was not a gift, it follows that none of its benefits were to revert to the plaintiff, and therefore no resulting trust was ever created. My God, having found that there was no resulting trust, or indeed any reversionary interest in the money, it truly follows that no accounts can be ordered. The upshot and result is that the suit fails and is hereby dismissed with costs. Dated and delivered in Mombasa on the 24th day of February 2017 by Justice P.J.O. Otieno, Judge. What are we learning from this? Foreigners who come to this country, you have been told you cannot own land. Foreigners who come and fall in love with Kenyan men or Kenyan women, you have been cheated that you cannot open a bank account. In the next episode, which is coming immediately, all foreigners in Kenya, both women and men, follow the next episode, because this is not true. The lady, this old woman, worked for 52 years, 52 donkey years. 52 donkey years. And I repeat, 52 donkey years, all her savings, 40,000 euros. She gave a man out of love. She was swindled. The court asked whether the gift was forced. Many men and many women in this country, you have given gifts to your intimate friends. This judgment serves as a warning. You cannot claim it back. You cannot claim it back. I repeat, you cannot claim it back. Once you have given a gift and you have not put there, but you are holding this gift as a trustee for me, that gift ends. From Court Helicopter, we bring it to you. The law is not as this mzungu was cheated. The law is coming in the next episode. Wakili Dan Senomari, always is a pleasure to bring it to you. For my friends who are foreigners, you're working for the UN. The UN is going to add 2,000 more foreigners coming to work in Kenya. The UN offices in Nairobi have been raised. Many multinational companies are in this country. Many of our Kenyans, our women are beautiful. Foreign men are loving them. Our men, young men, are handsome. Many foreign women are loving them. But the question is, don't be blind. Always watch Court Helicopter as we bring explainers to the foreigners. Wakili Dan Senomari from Court Helicopter. Thank you.